Every day in the USA, people find themselves in court.
Okay, Jason Altman.
Ready, Thanks, ready, Judge. That would be the,
Let me just ask you on a whole trial docket like this, we've had there are no pleas on these things. What's the deal, do you think? I mean, that's a typical response. What's the problem? I think we're the only court like that. Why is that? I mean, I haven't even had a chance to be heard on it, but there are no pleas. We're trying all of these. Oh, of course, you can only try one at a time. And we're backed up until 4,000 or 5,000 years. You know, it's another 2 millenniums before we can catch up. But all right, but I've done this so long that controlled substance cases get disposed of generally, and I just don't understand why there's and Samiski. Yeah. Have you talked to your client lately? The last one said they hadn't talked to you for 4 months before the trial, but that's a problem. Two of them said they hadn't talked to you for 4 months.
I've talked to her, not recently.
When? I mean,
this, even though.
where's Sarah Samiski?
The first person here.
I'll be.
This involves the death of the child. That's the injury is death.
Okay.
State is ready.
All right. Okay, and y'all are ready? All right. Y'all been talking with her? You've been working with him? When was the last time you spoke with him? A month ago, and we're in trial today. My God.
I have been trying to get a hold of his office and it like says like the phone number is different. And I also tried to message him and then I'm going through and
It's a trial today. Yeah, but y'all haven't talked to all y'all, I mean, we can go to trial right now and we're ready.
It's only Fridays from 1 to 4 and I've tried to call and haven't got anything. Yes, I did. I was like, not this.
It's the day for trial. You know, you got to strategize and prepare and, rehearse your testimony. You didn't even know you're going to be on trial.
I didn't get anything from him. I didn't get any letter, any phone call.
I'm sorry.
I didn't get anything from my.
That's
I'm not on Facebook.
that's not. Yeah.
But that's how I had gotten a hold of you in the chat. That's how I've always gotten a hold of you.
She was texting Facebook Messenger.
I don't know. You know what I would say. I've done this for 40 years and I've never come to a trial without being prepared with a meeting.
I'm ready to try. I'm not.
She hadn't talked.
No one told me anything about the trial.
She says she's surprised there's even a trial today.
The boss was responsible.
Not. You're not? Her lawyer is not?
I do my best.
What have you done? Oh, no, okay. All right. Well, I've never heard, this is completely, I've done this for 45 years and I've never heard of such, I've never heard of this.
I didn't hear until
Really.
today.
And then what they said last week when you weren't here at trial docket. So we had a trial docket, you didn't even show up.
I was in the trial.
Sir, you interrupted me just then. Sir, you interrupted me when I was speaking to you. Sir, I'm speaking to you. I didn't finish my sentence, if you'd be so kind. We had a trial docket. You never showed up for the trial docket, and the people there said they hadn't talked to you in 4 months. And it was obvious y'all weren't going to be able to go to trial. We had to go to trial on another case.
Notice order from Judge.
Sir,
because I was in trial.
Sir, once again, those are things you need to speak to me directly for, because the protective orders, look, we know what's going on with protective orders. And this court has a fair opportunity to be heard on its protective orders.
It wasn't a protective order.
Well, it's-
I did pick a jury.
This court generally doesn't do that, but I know some courts do, but I'm supposed to find out way ahead of the, I should know way ahead of the trial when that's being pulled, because the courts have a fair opportunity to be heard, especially ones that don't do the protective orders like I do. I know what goes on, and in some of the counties, it's kind of, it's subject to abuse, and that's not fair to the people who are the 22nd largest county with the 16th highest crime rate, like ours. I think we have some prioritization for the people of Jefferson County. You can't go to trial right now. Y'all aren't ready for this.
They tried, but we didn't know when, and that's the
Yes,
first thing I heard.
Okay, well, there's got to be preparation, and you just can't impromptu come up here and start testifying. It has to get rehearsed and things like that. Y'all just be seated, please. Y'all can be seated. Yes, you can be seated.
Just.
All right. Two cases are now called 23 CR 1236 and 23 CR 1385, the state of Texas versus Ashley Washington Molo. Is that you, ma'am?
Yes, sir.
Present with Mr. Adams, your attorney, and the state's attorneys. There are two motions there's a motion to revoke unadjudicated probation in each case. Do you understand?
Yes, sir.
We are ready to proceed today on this to dispose?
Yes, sir.
Please raise your right hand, ma'am. Ms. Molo, do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Thank you. Does the defendant waive formal readings of these motions? Can we proceed in summary?
Yes, sir.
Motion, number 23 CR 1236. The motion to revoke unadjudicated probation filed on August 19th of 2024 in that case states in summary that on November 6th, 2023, in this court, you were placed on 5 years deferred or unadjudicated probation for the state jail felony of theft. Is that true?
Yes, sir.
And I'm going to jump over real quickly and hold that one in abeyance, go to 23 CR 1385. And this is a motion to revoke unadjudicated probation, also filed on August 19th, 2024. And in summary, this alleges that also on November 6th, 2023, in this court, you were placed on 10 years deferred or unadjudicated probation in that case for the third-degree felony of continuous family violence. Is all of that true and correct?
Yes, sir.
Allegation 1 in each case states that you failed to report to the Jefferson County Probation Office for the months of May, June, and July 2024. Was she an absconder, and did she?
Yes.
For how long? Is that true and correct?
Yes.
You failed on that, but you were gone for a while here.
Yes, sir.
We didn't see her on May 24
Probably until she got arrested.
until she got arrested when? What was her date of arrest, please?
October 6th of this year.
Of this year? Okay. October of this year. So we've got about almost a year and a half.
Yes, sir.
Are you pleading true to allegation 1 in each of these cases of these allegations of failure to report and absconding from the Jefferson County Probation Office? Are you pleading true voluntarily? And because those allegations are true in each case?
Yes, sir.
You understand that knowing and voluntarily made plea of truth to one or more violations of probation, that is enough to grant a motion to revoke probation.
Yes.
Your probation can be revoked. You can be found guilty up to the full range of punishment in cause number 1236, I'm sorry, yeah, 1236. This is a state jail felony, though it's on its standby. Let me see. It's state jail felony. And you are looking at no less than 180 days up to 2 years in the state jail in that case. And in the third degree felony of continuous family violence in 1385, you are looking at no less, you were placed on deferred or unadjudicated probation in each of those cases. You can now be found guilty in each case and sentenced in this third degree felony to no less than 2 nor more than 10 years confinement in prison. Do you understand?
Sir.
Knowing that, do you insist on pleading true today in each of these cases?
Yes, sir.
I find you pleading true voluntarily. You understand and appreciate the consequences of pleading true. There are no agreements here?
Yes, no, sir, we're gonna use.
Okay,
I'll tell you, Judge, the
you may
reason,
go first.
Judge, the reason why I'm asking you to continue her on supervision and if not, change the deferred to straight probation and not any kind of pen or jail time. The offer was 1 year on the state jail and 3 years on the felony case. The reason why I'm asking you,
Wait, originally?
no, for
He's
today's.
referencing the deal I made offered today. Judge.
Correct.
Oh,
Right.
okay.
Just-
Okay.
Judge, the reason why I'm asking you to keep her on probation is twofold, Judge. If you look at the time where she did not report, and I think I'm looking specifically on page 2, and that's paragraph 1, where she did report in May, June, and July of 2024, and that's on the second page.
I know, but
I was gonna tell you.
that continued
Yes.
in August, September, October, November,
Correct.
December, then January, February, March, April, May, and when was she arrested?
October of
June,
2025.
July, August, September. Okay.
Right, and
I almost lost all my breath there by saying all those months. Okay.
right, something traumatically happened that summer, and I was gonna tell you what that was, Judge. When I talked to her, and to the right, to the back, is her boyfriend and then her grandfather, and they're here for support, and I can call them to talk to you, confirm some of this as well. Something traumatic happened to her that summer. She went to the ER and she found out that she had a mass that they believe was cancerous. She didn't have any insurance. She didn't have any Medicaid, Judge, and she went into a very, very deep depression. She did eventually get Medicaid and insurance. And while she was out, she did go to the doctor, and you can confirm. I think the doctor name is Dr. Amber Teal with UTMB, and it's to my understanding that as of this December the 18th, she has an appointment with that doctor. They're going to do a biopsy on the 18th at UTMB. I know part of the allegations was failure to work. She did establish a job at Cracker Barrel. She also, one of the allegations was doing the mental health assessment. She did, in fact, go to
She's
MHMR.
pleaded true to just one allegation, is all she's pleaded
That's
true to.
Right.
But it's the most important thing. If you
Right.
don't show up for work, you get fired. You gotta
Right.
show up.
Right.
No matter what it is, no matter what the situation, you've got to show up. And
Right.
we can accommodate issues. We do it every day with all the probationers that have something, but you have to do your part. If you don't show up and report, you're not on probation.
Correct.
You're not on my supervision, you're on your supervision, which is backwards, and we can't have that work that way. The law says the court is the supervising official, not the defendant of their own probation. And this happens from time to time.
And Judge, the reason why I was asking you not to send her to the prison is that, and even with the underlying offense, it was an issue with her and the boyfriend. And to my understanding, there's no problems with her and the boyfriend, even while they were out now. And I think that factored into why Mr. Ham offered a deferred adjudication. initially in this case. So she's not going to be a danger to herself or anybody else. At the end of the day, Judge, what you got here is a woman who is probably going to have some serious medical interventions. And that's why I had brought her grandfather and her boyfriend here today to establish that, as well as give you the name of the doctor so you can actually confirm yourself with the Dr. Amber Teal.
No,
And
I'm not going to do that.
No, I just,
That's y'all's obligation.
no, I'm providing that information. And what I was saying, Judge, is that the reason that she did that abscond and she was gone so long is that she went into a deep depression. And I think during the time that she's been locked up since October, we're now in December, she got her head together. And I think, Judge, with the support that she has in the back, and I pointed out the two individuals in the back, she has a place to stay. To my understanding, she will be allowed to go back to Cracker Barrel where you work, right? They'll take you back to work. And as far as paying any fees or if there's any kind of restitution on it there, she'll be able to do that. But the reason why that we did not take the 1 year and a 3 year offer that was given to us is that Judge, she has cancer and she has, well, I'm not going to say that, but hopefully she doesn't. But she does have that biopsy that's set on the 18th, and I'm hoping that it works out well. But I'm just asking.
Hold on for a second. Biopsy on the 18th for what?
Well, she had the mass on her breast, and I think Dr. Teal at UTMB, or you can speak for yourself.
Yeah, I have been
What-
living the same for a couple months now.
Right. So she's set to go to the doctor on the 18th in Beaumont at UTMB Beaumont.
And as far as the depression, I signed up with MHMR. They have me on anxiety medicine and the depression medicine, and mentally I'm doing a whole lot better.
Well, we can do the math here.
Mhm.
She just learned about her situation a few months ago. She's been gone for a year and a half.
For longer than that. I just
Oh,
started
when
going to
did the doctor determine that you had serious illness? When? What was the date
like in July
of what?
this year?
I know that was you had been gone a year.
Yeah, I found
You
out
had been
about it
absconded
Thursday.
for a year, ma'am. Okay. It's not like you found out and then oh my God, we got to go to an island and reflect on this somewhere.
Well, I found
You didn't know what your condition was for a year into your absconding, right? You had been gone a year. You just quit on the job and walked off. And you didn't know that wasn't a reason that you were sick. You just, for whatever reason, you got to report. You got to come to work or else you don't get paid. You got to report or you're not being supervised. The fact that you ultimately, after a year, understood that you had a medical condition, that doesn't purge the fact that you walked off the job for a year and you didn't have a diagnosis at that time. You made the decision to leave, but it's the same thing. I treat people the same way. That's the most important condition, or else you're not on probation. You gotta, there are so many conditions and we relax 95% of the conditions. But the one that has to be done, that has to be performed is you got to report.
yes, sir.
And when you walked off the job for a year and a half, I can't open the door for, okay, that's okay. I'm going to make an exception in this case because we have 5,000 probationers. They'd all go, I would like the Ashley Molo rule. She got to take a year off before it was understood that she had a medical condition, but she decided for whatever reason not to report. And then we just put her back on probation. That's not the way it works. And you got to report. But the court is not going to, it's not going to be harsh with you. I'm going to be fair. Anything else?
That's the
I know
main
what-
points I was going to make.
okay,
She can
stay.
speak to them. Well, I'm sorry.
By my estimation, that 20 months amounts to on average 30 days, those months. That means for 600 days, she decided not to do anything. And I love the excuse that's given. Primarily, I say it that way because the nature of that explanation means that every day she had to have been impacted by that. And by the nature of its explanation, that's not how that situation works. So that means that for 600 days, she decided she didn't care that the state offered her probation and gave her an opportunity to show she wanted to do right. Instead, as a PSI, you look at when she's been given probation before, each time it's been revoked. I went on, gave her another opportunity, gave her a chance to try to address the violent nature of the felony third degree that she's got. She didn't do that. And she just is thumbing her nose. There's no reason to give her the leniency they're seeking, Judge.
All right, anything else?
Don't say something yourself, please.
Yes, sir.
Go ahead.
I know I was on probation and I should have took it more seriously. I apologize for that. I'm on my medication now. I'm okay. I'm able to work. I'm able to go to any classes you need me to go to, counseling, anything that I need to do to get another chance so I can be able to take care of myself and my health.
All right. You're being straightforward with me.
Yes, sir.
How many convictions do you have?
I'm not sure.
What does that say?
What
What does that say of someone? That you've got so many convictions, 9 that I'm counting. You have so many you can't even remember. And you're intimately familiar with your own life. Most of these are thefts, crimes of dishonesty, which unfortunately follow you around when you attempt to make a statement. And I can tell you when, and the way the law works, when you make a statement in a court proceeding and someone has a counter statement that refutes that, the person who doesn't have the 9 convictions of theft is going to be more believed than the person who does, because the way the law goes to credibility. And the concern I have is I don't see any physician state, I don't see any medical proof other than a word to you that she's got a condition that she states. And how can I believe her when she had 9 convictions?
Judge, if it will help, I have Mr. Edwards and the grandfather of Mr. Smith.
I want to see a doctor's diagnosis in writing. That's all we can do. That's all we can really rely on in light of, the issues here.
What a biopsy is going to be scheduled for the 18th. So I think that's going to make.
See, all of this, we don't even know. You don't even know really what her condition is, but it's been portrayed as though it's something and it may be, but we don't know for sure. But it's portrayed that this was something that was understood long ago, and that's not true. That's not the fact. That's not factual. She absconded for 1.5 years, and she still doesn't know what her exact diagnosis is. So she can't really use that as an excuse. She certainly can't use it as an excuse because she didn't even seek the medical attention for after 1 year of absconding. And that's where the problem is, along with her rich criminal history. What's the state asking for?
And Judge, when I extended the offer that Mr. Adams has mentioned twice on the record, I was not aware that she had been absconded for 20 months. My goal at that stage was to try to address what I saw as just a disregard for the probation. But when you consider it 20 months at this stage, I think probably she needs to be revoked. I would suggest 4 years and 15 months state jail.
All right. Mr. Adams, on behalf of your client, what are you asking for?
Judge, I was asking, since she's on deferred adjudication, if the court was not amenable to keep her on deferred, then you can always change that to straight probation instead of deferred. And that would be a sanction because she would lose the deferred. And then at the same time, she better keep that appointment coming on the 18th for the biopsy. And like I said, I brought the two gentlemen there just as the support to show that they would be willing to get her to her doctor's appointments, get her to the most important thing, which is the probation, that she would have transportation, she would have a house to live under, and that's why they're here today, that they'll provide that. And
If she is incarcerated, the jail is going to make provisions to make sure she goes to necessary medical needs. They're not going to just let her sit in jail and let that languish. They have a responsibility to make sure that she goes to those situations. But let's just say she's not placed on probation due to the circumstances of this case and the rich criminal history. What are you asking?
um
The minimum.
yes, and yes, I'll be asking them.
Okay. You were looking at in each case, ma'am, of no less than 180 days up to 2 years in a state jail felony, and no less than 2, nor more than, was it second degree felony?
Third degree,
Third
Judge.
degree, and no less than 2, no more than 10 years confinement in the third degree felony. Do you understand?
Yes, sir.
Anything else to add?
No,
By anybody? Okay, in each of these cases, I'm going to find that there is sufficient evidence supporting the motions to revoke unadjudicated probation, to grant them by a preponderance of the evidence or greater, as allegation 1 is proven true in each case. She failed to report and absconded from probation for approximately a year and a half. That is enough to grant these motions to revoke probation by preponderance of the evidence or greater. Thus, your probations and your deferred or unadjudicated probations in each case are revoked. In each of these cases, you have pleaded guilty voluntarily earlier. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in each case to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in each of these cases. Stand by on the theft case. Is there restitution on this? No restitution.
I didn't see that. I believe they recovered all items, Judge.
And there is enough evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in each of these cases. And in this state jail felony, you were hereby sentenced to confinement in the state jail for 180 days. In the third degree felony, you were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years. These sentences shall run concurrently. These are the minimum in each case, even though the state's requests are reasonable. I find under all of these circumstances that probation, it just is not realistic under these circumstances. But the court finds that the minimum sentences in each of these are appropriate based upon these sentences and the Christmas season. Anything else?
That's it, Your Honor.
That is all.